Welcome to our webinar on the new UAE labour law and the executive regulations that were issued just recently. We held a similar webinar in December, and this is a refresher to take into account the updated position as regards the executive regulations. I'm joined by my colleague Sabrina. Do you want to say hello, Sabrina?
Hi, everyone.
And just some housekeeping matters before we get started. Number one, this webinar is being recorded, and we'd be very happy to share the link with you afterwards so you can share it with any colleagues who couldn't join us today. And number two, there's a chat function on the portal, and we're happy to take any questions. We're probably going to take about 40 minutes to get through the material, and then we'll have about 20 minutes at the end to take any questions. So please do feel free to use the chat function. We will also share the slides afterwards for all attendees. So again, no need to sort of take notes or start scribbling too much. You can sit back and hopefully enjoy the presentation. So the agenda for today is, firstly, we'll do a quick recap of where we were after the first webinar. We appreciate a lot of people on this webinar would have attended the previous one and may have some general familiarity with the new labour law. So we don't want to rehash all of that. So we will do a recap, and then we'll structure the rest of the presentation into pre-employment considerations, during employment considerations, and post-employment considerations. So just by way of quick recap, the labour law was unveiled in November 2021. It came effective on the 2nd of February 2022. And at the time, it had a lot of placeholders whereby it said further details will be provided in executive regulations. So when we give this first presentation, a lot of the time we were saying, let's see what the executive regulations say. Well, now we have the executive regulations, so we are in a position to say what the position is, and there's not much else to wait for, you know, other than the court practice and some of the procedures. There's no extra statutory element to wait for. So you know, it's not as if in 2 months' time there will be another regulation issued in relation to the substantive part of this law. So we have the law. What we don't have is the practice, obviously, or the case law, but we'll discuss that shortly. And we also will discuss what we understand is occurring at the Ministry of Labour level as regards new contracts, and also at the free zone level. And just to recap again on who does this law apply to, it applies to all employers who are registered with the Ministry of Labour, all free zones with the exception of ADGM and DIFC, and it also applies to employers who are not registered with the MOL. So we have some employers who are majority owned by government, directly or indirectly. They're subject to the Labour Court and the Labour Law, not the Ministry of Labour, but they are still subject to the law. Obviously, areas around template contracts issued by the Ministry of Labour would not apply to them because they do not use those template contracts, but 90% of the law does apply to them. So moving to the types of contract, and I mean, if I'm sure you've heard this umpteen times, but just to reiterate the point, you know, the key takeaway from if you know, if you have to take one takeaway from today, it is that unlimited term contracts are no more. From now on, we have to issue fixed term contracts for all new employees, minimum 1 year contract, maximum 3 year contracts. And for existing employees, we're going to have to move them across to fixed term contracts within 1 year. So we have a grace period until February 2023 in order to move existing employees across. Practically speaking, we don't need to issue new contracts for existing employees. A lot of our clients are issuing new contracts because they've taken a look at their existing contract and taken the view that it needs a bit of a spring clean, it's out of date, and they're using this as an opportunity to update their contracts. But you know, we have some clients with thousands and thousands of employees with maybe dozens of different template contracts, And they're not doing that. They're going to issue amendment letters whereby the contract, the amendment letter just says that the contract is renewed, amended rather, into a fixed term contract starting on this date, ending on that date, and all other terms are the same. So for some existing employees, they will not be getting a new contract. It'll just be an amendment letter. The choice is yours as employers, and it really depends on what's driving it, the number of employees you have, maybe the sophistication of the employees. Maybe you don't want to be issuing long contracts, and also the state of your current templates, whether they're good templates or whether they're not, and whether this is an opportunity to change them. One question we often get asked is, can we do a wholesale change of the contracts, notwithstanding that the law says, towards the very end of the law, it says that basically employers shouldn't be changing the terms and conditions unnecessarily. I'm paraphrasing, but that's basically what the law says. In our view, that means that employers shouldn't be reducing fundamental benefits. So, it shouldn't be reducing annual leave, increasing working hours, reducing salary, these type of things. In our view, the focus is not on what we call business protection clauses. So if an employer decides to use this as an opportunity to spruce up their post-termination restrictions clause, their confidentiality clause, and some of these other clauses, in our view, that's not going to be an issue. That the focus is really on reducing employees' benefits and using this as an excuse to do that, which would not be permitted. But it is an opportunity to look at the contract. And as just to reiterate, we do have until February next year to do that. Before I hand over to Sabrina, just a final point on the contract types and the transition period. Some clients are saying, we're going to wait until January 2023 to make the transition. And, frankly speaking, there's no first mover advantage in changing. There's no advantage in you being the employer that's going first and moving everyone across to fixed term contracts next week. But on the other hand, there is a consideration in relation to having, if for example, we moved all our employees in January to fixed term contracts on the same term, then in January 2026, that term would expire for all those employees. So from a strategic point of view, not a good position to be for the company. Hence, a lot of employers are doing this in waves, or have said that they will do it in waves of employees starting Q2, Q3 this year, and start moving them across so that they don't have a situation where all the employees' expiry dates are at the same time. Sabrina, will you take us through the different types of employees?
Yeah, absolutely. Thanks, Ivor. So I wanted to run through just very briefly on this slide, because I appreciate that we've already discussed this in our previous webinar. But as all of you will know, the old law really only made provision for full-time employment. And although part-time was a concept that was recognised in the ministerial resolutions, the law in itself didn't expressly provide for part-time working. The new law does make provision for a number of flexible or alternative kind of working arrangements. The first one being, now it makes express provision for part-time. And in part-time working, there are prorating entitlements for annual leave and for gratuity. And later on in the presentation, we'll discuss how those prorating entitlements are calculated. The law also makes provision for temporary working, which is applicable where time or a project objective is kind of a determining factor in the length of the employment period. And the law also makes provision for flexible working, which is kind of varying hours of work and days of work depending on workload or economic and operational variables of the employer. In addition to those, the new law also makes provision for remote working, which is a concept that we've all become more accustomed to and a lot of us have begun to love as a result of COVID. And then additionally, I've highlighted in red job sharing, which is a type of alternative working arrangement that's expressly provided in the executive regulations, but actually isn't provided in the new law. And I think that these type of alternative working arrangements are great, and it's really reflective of the immigration landscape that we see is evolving and has taken kind of a big push in the last few months. So on the next slide, I wanted to just run through with you the different work permits that the new law makes provision for. So in the executive regulations, quite substantially, there are 12 different types of work permits that are introduced. The first one, and I only wanted to run through a couple of them with you, not all 12, because we don't have time in this presentation, but the main one obviously is the permit for external recruitment. It's the one that we all know, the 2-year for ministry employees, the 3-year for free zone employees. That's obviously still available and still applicable. The other couple that I wanted to mention is the dependent work permit. So this is a work permit specifically for those individuals sponsored by a dependent, so a spouse or a parent. And previously, under the current position, those individuals sponsored for residency purposes by a dependent are still required to apply for the normal work permit, but now there is a specific work permit available for dependents. There is also a specific work permit available for golden visa holders. And golden visas, as you know, have picked up in the last 6 months or so, and there are a lot of individuals now having approved or are applying for work for golden visas. So there is a specific work permit now available for individuals who have and who are sponsored under a golden visa. The third one that I wanted to mention is the self-employment permit. And this is actually a really interesting new permit, because the existing landscape is that all individuals who work in the UAE have to have a work permit, and as part of that work permit application have to submit an employment contract to the authorities and have that employment contract approved. Now, the self-employment work permit is obviously granted to individuals who are self-employed, but interestingly, this permit allows individuals to work in the UAE on a self-employed status and without the requirement of having to submit an employment contract to the authorities. And that's quite a dynamic change in the existing kind of immigration and work and employment landscape. And it shows that the UAE is really proactively encouraging various different types of working arrangements. And that's quite extremely welcoming, I guess, given the historic position with only one type of work permit really available.
Thank you, Sabrina. And the questions are coming in thick and fast. Please keep them coming. We will come to them at the end. I might just pick up, because I saw a few on my slides in relation to MOHRA contracts. Just to explain that MOHRA will be taking the lead in relation to issuing the new fixed term contract. We have seen a template of the new fixed term contract that MOHRA will be issuing. The free zones will also be issuing their own. We expect them to take the lead on that, whereas for your own internal contracts, obviously that's up to you. And that's just scraping the iceberg. I know there's a lot of more questions on that, which we'll come to. Just briefly on probation, just to explain some of the queries that we're getting about that so far. I mean, there's no huge seismic change as regards the probation period, still 6 months. The changes are that notice is now required to be given during probation, 14 days or 30 days if the employee is joining another company in the UAE. But I suppose most of the queries that we're getting are around recovery of recruitment costs. It has the law says that if the employee joins another employer in the UAE, that the first employer can recover the recruitment costs. People ask us how is that going to work in practice? We don't know, because well, other than you could go to the court and pursue a claim against the second employer, that's obvious, but not very efficient and probably costs more than the cost, the cost that you're trying to recover. So, it's an open question. Will there be some system to help the first employer recover the recruitment costs sustained as a result of that employee then leaving and joining another employer? And the answer is we don't know what system other than the court system, which, as I said, is not going to be particularly user friendly for the first employer. Leave landscape, I don't intend to go through this. We will share this with you on the slides, and I'm sure most people are aware of this already. The executive regulations have not added very much other than some provisions in relation to leave where an employee wasn't allowed to take leave for 2 years. So, you know, we're talking about probably 1 in 1,000 cases where an employee wasn't allowed to take their annual leave for 2 years due to business needs. And there's provisions in the exec regs for that. There's nothing material in relation to the other grounds, which are all covered here, all pretty clear, I think. We're not getting that many queries on leave, but happy to check the chat function later to see, does anybody have any particular queries on it? On working time, we have discussed some of these changes. We have got some clarity from the exec regs as regards the exemptions to overtime. So under the old law, it was a bit clunky, to be honest. You know, there was various debates at the Labour Court whether these senior people like general managers and supervisors, whether they needed to have the written delegated authority of the company in order to be exempt from overtime. I mean, it's quite a clunky conversation. Most companies would only have a handful of people out of the delegated power of authority to bind the company into contracts. So, you know, practically not very helpful. The new law has widened it and hasn't mentioned delegated power of authority. But more importantly, I think, in the new law, and you see the grounds here in the bottom right hand side of the slide, but one of the interesting ones is shift work. So for companies that are operating on a technical nature, so we're talking about generally heavy industry, we're talking about assembly lines that are working 24/7, 365, those type of industries that this would apply to, whereby the normal working hours would be up to 56 hours per week before overtime would kick in. That wasn't in the old law, so that is I would say a welcome change for a lot of companies that are working on round-the-clock basis. And Sabrina's going to take us through the disciplinary slide.
Yeah, thanks, Ivor. It's a bit of a chunky slide, I know, but I wanted to kind of set out the disciplinary process as per the new law and the executive regulations. It isn't drastically different to the existing position, you'll be pleased to know, but there are some changes, so I thought it would be helpful just to run through those. And I've split the slide in terms of kind of policy, law, and then consideration of both, and then what would really be best practice. So the law does provide for a minimum process. As I said, it's very similar to the existing position, whereby an allegation is raised, the individual that the allegation relates to should be notified in writing of that charge. An investigation should be undertaken by the company. As part of that investigation, the individual should be invited to a meeting, his representations should be heard and discussed, and the investigation should then be concluded, taking into account the employee's representations and the penalty imposed, if applicable, to the employee in writing. So that's the minimum process under the law. Not particularly prescriptive, but there is a very minimum process that should be followed. Now, I'm sure that the majority of you probably have a policy in place. It's important to ensure that that policy is compliant with the minimum process under the law. I imagine it's probably more detailed, which is great. And then we look at those, both of them combined, in terms of what would be best practice when imposing a disciplinary sanction, when going through that disciplinary process. And I've set out a kind of process here.
Sabrina, I think we've lost you. I think you're frozen. Joanna, can you confirm, or is it just me?
Yeah, we have
Yeah.
Sabrina is frozen. Yeah.
No problem. I'll take on this slide. So look, the key difference is, as Sabrina said, that under the new due process requirements, there's this appeal element, and under the old law, there's never any requirement for an appeal. So in that sense, we're going to have to update our HR policies. We're going to have nominated people who could fulfill the function of an appeals officer. So, for example, obviously HR would normally manage the disciplinary process. We would need somebody, they could still be in the HR department, but separate, on a separate avenue, so to speak, that were not involved in the initial decision in order to deal with any appeal. The law doesn't say that, that's just a principle of natural justice. And Sabrina, I'm not sure, are you back with us, or whether there's anything you wanted to add to that slide at this point? Okay. Well, look, I will move on to the juicy bit. Not that disciplinary is not juicy, but termination is obviously really juicy. And, you know, just to explain the termination landscape, number one, expiry of fixed term contract is actually not a termination. So that's a natural occurring event, and it's not a termination. To use the example, if the contract expired on the 30th of June, 2025, then on the 1st of July, that employment is over. There's no notice payable. There's no compensation payable. There's absolutely no doubt about that. All that is payable for a non-national is end of service gratuity. Obviously, a national would have the pension entitlement already taken care of. Now, if we terminate mid fixed term contract, then that's a different scenario potentially, and we're going to talk about that shortly. As regards our old favorite Article 120, as per the old law, which is Article 44 of the new law, look, in practice, not an article that was very well received in the Labour Court, shall we say. The Labour Court really didn't like to apply a summary dismissal. So most cases actually failed in the Labour Court, except for the blatant ones, like, for example, being absent without permission for a certain number of days. But the other ones, for example, breach of confidential information, being under the influence, maybe assaulting a fellow employee, these were all criminal offences, as well as being Article 120. And the Labour Court would generally say to the employer, if you felt that the employee was guilty of this, where is the criminal conviction? And Article 44 has made a few little tweaks, but look, frankly speaking, we don't see it as something that employers are going to rely on, particularly because the only upside of Article 120, the old gross misconduct, was the forfeiture of the end of service gratuity. That doesn't apply under Article 44. The employee never, ever forfeits their gratuity, no matter what. If they've done more than 1 year's service, they are not sustaining a forfeiture of gratuity for gross misconduct. Likewise, even if they resigned with less than 5 years service, per the old law, there was a sliding scale of reductions. That doesn't apply either. Then we have mutual agreement, which is the amicable settlement scenario. That's still a viable way to exit, and probably the most common way to exit employees, particularly poor performers. And then we have redundancy, which for the first time ever has actually been legislated for in the UAE. And we're going to talk about that. I don't want to get people too excited about redundancy, because the law said further details in executive regulations, and those executive regulations have spelled it out, and frankly speaking, it'll be used in probably 1% of redundancy scenarios. And by that I mean, when we get redundancy queries, it's generally about a business line being closed, a unit being closed, a team being closed. It's extremely rare that we're talking about the entire company being closed. And that's what this new law provides. So not something that we're going to be using very often in practice, not something that's very helpful to a lot of companies here who are thinking about perhaps restructuring a unit. It's not something that we're going to be able to use, frankly, but the details are there in relation to it. The $1 million question that we're getting asked every hour of every day since November is arbitrary termination still available to an employee? And I saw from the chat function, people are asking also about early termination compensation. And just to explain, under the old regime, if you're on a fixed term contract, the compensation was early termination compensation, 3 months. If it was an unlimited term contract, it was arbitrary dismissal compensation up to 3 months. The new law doesn't mention either of these grounds. You won't find those terms in the new law, but the new law does have this Article 47 that looks and feels a little bit like arbitrary dismissal compensation. However, it's not clear cut, and in fact, on a literal reading, for an employee to succeed under Article 47, he or she would have to file a case, either a labour court case or a ministry or free zone complaint prior to their termination date. I mean, this is a really important element to this. They would have to file a complaint prior to the termination date. Then if they're terminated because they filed that complaint, then they could go to the court and plead Article 47 and seek up to 3 months compensation for that breach. So that's, the exact opposite of most cases that were, pre the new labour law. Most cases, the employee filed the case after he was terminated and went under Article 122 of the labour law, the old labour law, and got the 3 months or up to 3 months compensation. So there's a very important differentiation. It seems to mean that only employees who are victimized, that victimization will be the term used in a lot of Western countries for this. If the employee brings something to the company's attention and is punished for it, and he did it or she did it in good faith, or they were subject to discrimination or harassment, or then terminated, then this is what Article 47 is for, is what the literal reading seems to suggest. The big but, though, is that although the labour law changed on the 2nd of February, the labour court didn't change, the labour judges didn't change. They have a track record, 41-year track record of awarding compensation for arbitrary dismissal, for a dismissal mid-contract or for a reason that's undocumented or unverified in relation to performance or conduct. And the thing that makes us think that there's still a risk of an unfair dismissal compensation is that the judges haven't changed, and the award under Article 47 is exactly the same as it was under Article 122. I mean, this is, I don't think we can overstate the significance of that. The award is exactly the same as an old Article 122 award for unfair dismissal. So the only thing that's going to settle this debate is a cassation decision. So cassation is the highest court in the UAE. And by the time cases get there, even there's obviously cases starting every day of the week. Cases have already started, and maybe one of those cases may reach cassation. That could take, it mightn't be 2022 before we have that clarified. It's unlikely, in fact, that we would have that in 2022. So what do we do in the meantime? Our view is that a risk remains. If we terminate an employee mid-contract, there is a risk of compensation. It's very difficult to quantify the risk. I would say the risk in Abu Dhabi is higher than Dubai, just from the track record of those courts. I would say if you terminate a UAE national as opposed to a non-national, the risk is much higher. But we simply can't quantify because the law has left the door open to judicial interpretation, which is always the case, of course. So let's see what the courts say on that one. And I'm sure there'll be lots of questions which we're happy to answer. Sabrina, I think you're back with us. You've managed to dodge the bullet on disciplinary proceedings, so don't worry about that. I think we covered it. But if you want to pick up the pro rata element, so this is the post-employment phase of the presentation.
Yes. So thinking now in terms of termination, entitlement and termination, what happens following termination? I mentioned at the beginning of the presentation that there are certain scenarios where individuals are entitled to a prorated entitlement of gratuity, and I've set them out clearly on this slide here just to clarify. And it's actually quite interesting in terms of which types of employees are entitled to which types of prorating. So for annual leave, the law expressly provides, and the executive regulations expressly provide, that part-time employees are entitled to prorated annual leave. But for end of service gratuity, The provisions in the executive regulations actually provide that both part-time and job-sharing individuals are entitled to prorated gratuity. Those two entitlements are the only two entitlements that can be prorated, and the law and the executive regulations don't provide for the prorating of any other entitlements. So, for example, sick leave, maternity leave, parental leave. These entitlements are, under the law, still full-time entitlements, and there's no prorated part-time equivalent. And I've just set out the bottom of the slide the calculation of those prorating of entitlements for gratuity. And effectively, the way that the law calculates it is based on full-time equivalent hours, where full-time, where one day or one full day of working hours is equal to 8. And you would then calculate the number of working hours for a particular individual against
Sabrina,
full-time
sorry to interrupt. Some of the guests are saying that your voice is a bit broken up and low. I'm not sure. Can you get a bit closer to the microphone?
Sorry, can you hear me now?
That seems better. Yeah, thank you.
Fine. So in terms of the calculations, I'll just repeat what I was saying. But the way that the law calculates it is as if one full day is 8 working hours. And you would then equate that with the number of working hours of a part-time or a job-sharing employee. So it would be the number of working hours for that individual over the equivalent full-time hours, and you would then calculate their prorated equivalent in that way. The next kind of post-termination slide that I wanted to discuss was post-termination restrictions, and this is very similar in kind of format in terms of the disciplinary slide that I didn't get to go through with you. But what I've done on this slide is kind of set out the contractual provision, the law, and then kind of a flow chart of the considerations that employers should bear in mind when trying to enforce post-termination restrictions. So as we mentioned in the earlier webinar that we had in November, the law does provide for non-compete provisions, and those non-compete provisions can be up to 2 years in duration, but there are no specific kind of remits or limitations in terms of geographical scope, nor in terms of the activity or the nature of the restriction. Now, if we look at from a contractual perspective, is your contract or are the provisions in your contract in terms of those restrictions compliant with the law? Does it have a minimum or a maximum, sorry, of a 2-year restriction? Is it longer than that? So in terms of, if we look at the flow chart, we need to look at the contractual provision first. Does your contract contain a provision around non-competes? Obviously, if it doesn't and there's no separate agreement in place in respect of non-competes or post-termination restrictions, it's not going to be enforceable. There's no way to enforce a provision that hasn't been expressly agreed with an employee. If we then look at the scope of the restriction, again, this is looking at the law. What does the law say? Okay, you can have a maximum of a 2-year restriction. There's no specific geographical scope. There's no specific activity or nature of the duties to be restricted. We would need to again look at the labour court approach. I mean, historically, the labour courts were inclined to consider a 6-month restriction to be reasonable within the emirate in which the individual is working and limited to those activities or the duties of that individual in their existing employment. Now, the law now provides for a 2-year restriction. Whether the labour courts would accept a 2-year restriction as being reasonable in the event of a dispute, we would have to wait and see. Again, as Ivor said, you know, for cases to be brought before the courts and to see how the courts react to that. When is it applicable? That's quite an interesting one, because under the previous or the historic position, provided that you have agreed a post-termination restriction with an individual, it is applicable in all circumstances, irrespective of the reason for termination, whether initiated by the employer or whether the employee resigned. Under the new law and the executive regulations, it has been made clear that you can only enforce, or a post-termination restriction can only be applied or imposed against an individual employee where that individual resigns. So if an employer initiates termination of employment for whatever reason, the post-termination restriction in itself is not enforceable and cannot be imposed against the individual. The next option is obviously, is it enforceable? Okay, well, we're looking at the applicability of it, and again, the scope of the restriction. Would it be enforceable to have, for example, a longer restriction than 2 years? Probably not, because the law makes express provision for a maximum of a 2-year restriction. Again, we would be looking at the Labour Court's view and whether or not the Labour Courts would consider that to be enforceable in the first instance. And the last point that I wanted to raise, which is actually quite important and it's quite significant in the new law and the executive regulations, is whether the restriction can be waived. And this is a provision that wasn't contemplated in the old law and it wasn't contemplated in the new law, and it's actually come about in the executive regulations specifically. So the executive regulations expressly state that the parties, so the employee and the employer, can agree to waive post-termination restrictions in 3 specific scenarios. The first one, which is probably the most relevant for everyone and the most interesting, is where the employee or their new employer agree to pay compensation to the old employer of 3 months' salary. And the reason that that's interesting is because the provisions under the law only provide for compensation for damages incurred by an employer where an employee goes to a new employer in breach of their restrictions. So in that scenario, in order to, I guess, enforce post-termination restrictions, an employer would be required to file a claim. That claim would have to be held as successful, and as part of that, the employer would have to adduce or calculate the damages incurred by them by the employee as a result of the breach of their restriction. In this particular case, the employee and the new employer would agree with the old employer to pay a 3-month compensation to the old employer. And obviously, the benefits from the old employer's perspective is, number one, there's no requirement to go through that labour proceedings to incur costs and so on. And the second and I guess the most advantageous point is that it's often difficult to determine the level of damages incurred by an employer as a result of an employee's breach. And in this particular case, it's much easier then to agree with a old and a new employer that an X amount will be paid as a result of the breach, without having to go through that process of calculating damages and also going through the labour court process. The second reason that individuals could agree a mutual agreement is during probation, so where the employment is terminated during probation. And the third is occupational categories as determined by the ministry and approved by the UAE cabinet. So in those particular scenarios, it would be where an individual is particularly required by the UAE in a particular role or a practice area, and it's decided that that individual shouldn't be subject to a restriction. And then the final thing I wanted to mention is on labour bans. So labour bans was expressly provided in the previous law, although from a practical perspective, imposed less frequently. Now, labour bans again have been provided in the new law and in the executive regulations, but I think more prominently. And it appears as though labour bans are kind of having a comeback, as it were. So labour bans under the new law and the executive regulations now provide that a ban can be imposed of up to 1 year where an employee resigns during their probation period. And it can also be imposed for where an employee or for an illegal reason. The scope of what would classify as an illegal reason isn't very clear, and it would be determined on a case-by-case basis. And as Ivor and I have mentioned throughout this presentation, of course, a lot of these kind of vague terms will be kind of clarified, I guess, as the years go on and as future cases come to court, and as labour bans are imposed by the authorities, and we come to know the scope of what would classify as an illegal reason constituting that ban. The executive regulations do make provision for certain exemptions to labour bans. Interestingly, dependent visa holders are not subject to a ban, nor are golden visa holders. And that's quite interesting because there's no clear reason as to why those two particular groups of or categories of individuals should be exempted from a labour ban, but it is expressly provided in the executive regulations. Separately to that, again, we have this occupational categories and also individuals of the skill, professional or knowledge levels. So again, individuals that the authorities deem to be important to the UAE from a commercial and business perspective, who should not then be subject to a labour ban. So if we then, I guess, consider as an overall, what are your takeaways? What are your next steps? And we move to the last slide. We're looking at have you updated your contracts? As I've mentioned, perhaps you want to consider amendment letters as opposed to full contracts for sorry, existing employees. Of course, for new employees, you will need to have a new contract in place that's in line with the law, a fixed term contract and so on. As we've already mentioned, again, your policies will need to be reviewed and updated, especially where the, let's say, entitlements have changed, the processes have changed, and so consideration should be given to, how you will start to review those documents, implement those documents over the next year.
Thank you, Sabrina. And just to, the questions are coming in thick and fast. And just to, I know some of them hopefully have been dealt with in the presentation, but we will get to as many as we can in the remaining time. One thing just to mention is, because I've seen some questions about end of service gratuity for those that are on a currently on an unlimited term contract with less than 5 years service. So for example, the employee was hired on the 1st of January 2018. He resigns today. Is there a reduction to his or her gratuity? Yes, there is, according to the new law. There's a section in the new law towards the end that basically says the old unlimited term contracts gratuity will be calculated in accordance with the old law. This is a bit peculiar because obviously it means an older employee is worse off than a new employee, because a new employee, there's no such reduction, but that is provided for in the law, and it's pretty crystal clear. But I'll jump into some of the other questions and go through them as succinctly, shall we say, as we can. Somebody's asked, can we have a contract less than 1 year minimum? The law says no, and I think the ministry will say no, and the free zones will say no. The template, the minimum template, will be 1 year. Look, the reality is, as you've seen from our discussion about the termination, if you hired somebody for 6 months, then the entire probation period would be their contract. So you could terminate them without any penalty, and even after the 6 months, if you want to get rid of them at 9 months, then there's an argument per Article 47 that there's no compensation payable, and even if there was compensation payable for that limited service, the courts wouldn't give more than a month anyway, in our experience. Somebody's asked, how do we determine the date of the contract amendment? Are employers free to choose 1, 2, 3 years, or must they align with the visa period? No, they do not need to align with the visa period. And in fact, under the old regime, in most cases, the fixed term contract was out of kilter with the visa, so there's no issue there. Some employers are telling us that they're going to put employees who are who've had bad appraisals, have scored low in appraisals, they're going to give them 1 year contracts, and they're going to give others 3 year contracts. So you might see that differentiation within the same workplace. Good question. Somebody's asked, when converting from the unlimited to the limited, what's the start date that we put into the limited term contract? Well, what we do is we have two defined terms in the contract. One is the commencement of the contract, and then one is the original commencement date. So if the employee was there since the 1st of January 2010, then that is the original commencement date for which gratuity and everything else will be calculated. But the start of that particular contract is, for example, the 15th of February 2022. Many questions about should we have to pay gratuity when the contract changes? No, and then we're 1,000% clear on that. The employment relationship continues. All that we're doing is changing the nature of that, but we're not actually, still an employment relationship. There's no gap. There's complete continuity, so there's no question of paying out anything. So everything just rolls over into the new contract. We have some questions on early termination compensation. That no longer exists. But as we said, Article 47 might be similar to arbitrary dismissal compensation. And just to explain as well, I suppose that the new fixed term contract, it's really fixed term in name only. All its other characteristics are similar to an unlimited term contract. Questioning, do these contracts renew automatically? No, they don't. But I would say 95% of our clients have asked us to draft it so that it is renewed automatically. So we put in what we call an auto renew clause, and basically the parties don't have to do anything. It will renew on the same term unless notice is provided by either party not to renew. Now, some clients are saying we want that notice to be longer than the notice for termination during the contract because they don't want high staff turnover. For example, if the notice period in the contract is 1 month, it mightn't be ideal for existing employees to be waiting until 1 month prior to their expiry in order to renew their contract if we don't have an auto renew. Because as we said at the outset, that employee would be left with nothing, no notice, no compensation upon the expiry of the contract. We have questions about various free zones and what they're doing. It's early days, but we do expect the free zones. I mean, they're already working on this and they will be issuing their own contracts. But for most people in this call, they will also be, they'll have two contracts, the free zone stroke MOL contract, and then their internal contract, which is what we're talking about renewing. The free zones administrator will look after those other template contracts that will be need to be sorted out. Sabrina, do you want to pick up any queries that you're seeing coming through?
Yeah, sure. I'm seeing a couple about annual leave carry forward from this year or from previous years, given that the law now doesn't provide for carryover of leave. And that's actually quite an interesting one. And we have debated it internally as well. But the new law doesn't provide for carryover of leave unless the employer specifically wants to provide that entitlement for its employees. So obviously that's a completely contrasting position from the current position or the previous position where any leave couldn't be forfeited, and if it hadn't been used in any 1 year, it either had to be paid out or it had to be carried over to the following year. So I think that given now that the new law has been implemented, if employees have any leave that they have continued to accumulate up until now, that leave should be either, the employee should either be allowed to take that leave this year or it should be paid out this year, following which employees will then be only entitled to take the leave that they are entitled to within that leave year. If they don't take it in that leave year, then that annual leave entitlement will lapse and they will then be entitled to their new leave entitlement in the following
year. Yeah, thank you. I will pick up somebody asked if we break the contract, is the compensation to be paid? Well, there's notice to be paid by either party or served rather, and if it's not served, then paid. But there's no bar this Article 47 that we keep coming back to, which might lead to some compensation for a break of a contract by the employer. The employee won't be paying anything. That's for sure. So under the old regime, the employee would be paying compensation for breaking a fixed term contract. That's definitely not the case under the new one. Somebody's asked us about study leave and what are the accredited institutions. I believe there's going to be a schedule produced, but there'll be no surprises. They will all be the accredited UAE institutions, not international ones for study leave.
There are a couple of questions on leave, limited term contracts and how notice periods can be included in contracts. So although the contracts going forward are fixed term, they are also terminable on notice. And the maximum notice period is 90 days, so anywhere between 30 and 90 days, and it can't exceed 90 days. On top of that, if there is no auto renewal or the contract has not renewed at the end of the expiry, then the contract will automatically expire at the end of the term.
Yeah. I have a question about gross misconduct, and there's a new ground where the employee illegally exploits his position to obtain personal benefits. And Dana, thank you for this, because you've asked then, will the courts require a criminal conviction? And I'm sure they will, because of the word illegally exploiting. And it goes back to the earlier point about the old Article 120. You know, 7 out of those 10 grounds were criminal offences, and the court would expect a criminal conviction, which would mean, practically speaking, not a very attractive option for an employer, given it would take almost a year to go through the criminal courts and the appeal courts to get that conviction. So I don't see I think Article 44 is, I wouldn't want to say dead on arrival, but I just cannot see it being used very often, unless for the cases where people are absent without leave. I mean, that's a pretty straightforward situation to establish, but I really don't see it being used very often thereafter.
There are a couple of questions on recovery of recruitment costs. And I just want to clarify that the recovery of recruitment costs is only possible during probation, so not for the first year of employment. And it's only recoverable by the new employer in the event that the employee resigns and moves to another employer in the UAE.
Thanks, Sabrina. More questions on the gratuity calculation. It's 21 days now, and 30 days after 5 years pro rata. There is no differentiation if somebody resigns or is fired for gross misconduct, as we said. So it simplifies things. And just to clarify, there was talk around the place in November when the first law was issued that gratuity was changed to a working days calculation. We can clarify that's not the case. That was a typographical error. It is certainly calendar days. There is no change on that one. I think we've covered quite a few, Sabrina. Are you seeing any more that I'm missing, maybe?
No, I don't think so.
Any
more gratuity, just to highlight, there was one about 30 years worth of service. So the gratuity itself is still subject to a cap of 2 years total salary. So that's the same as the previous position in terms of the gratuity cap. So where an individual has generally around more than 22, 23 years of service, their gratuity will be capped, and that cap is at 2 years total salary, and that's the difference between the cap at total salary compared to the gratuity calculation in itself, which is calculated on basic salary.
Thanks, Sabrina. Question about the amendment letter. Can it be unilateral in nature? No, it can't. It's got the same legal basis as a contract. It needs to be signed by both parties. It can be done electronically. Just to be clear, we don't need to over-engineer this. It can be done electronically, where it's sent by an email and they click on a button that sends them to a landing page, and their IP address is recorded by your IT team, and that is proof that they have signed the contract. So that should be a relatively straightforward thing to do if you're telling the employee that you're only doing this because it's not your idea to change everyone to fixed term contracts. You're merely following the law, and they need to get with the program basically and sign on the dotted line. Somebody's asking, at the end of the fixed term contract, do we need to give notice? No, we don't. If we don't have an auto renew clause, the contract expires naturally. There is no need to serve any notice. If we have an auto renew clause, then we do need to serve notice. The auto renew clauses, you might see them in JAFSA and DAFSA. They have similar type of clauses, but obviously we can support anybody that needs assistance on that. 3-year option, is it only available for free zones? It's available for everyone. but it does raise an interesting ancillary question. Will visas be extended to 3 years for onshore? So currently, visas in free zones and in governmental entities, entities owned more than 50% by the government, are 3-year visas. So will we see the onshore MOL issuing 3-year work permits and 3-year visas? It remains to be seen. The law hasn't said anything about that, and in fact, it wouldn't be within the Ministry of Labour's power to decide that. That would be for immigration to do. But we haven't seen it, and there has been a new immigration law actually, but we haven't seen any change there. Somebody's asked, at the end of the 3-year contract, do we issue another one? Well, we have the auto renew option, or we can do an amendment letter. Either way, as long as we have the evidence in writing of that. Adele has asked about redundancy provisions. Happy to give further details, Adele. I don't think it's going to be relevant to most people on the call, given how narrow it's been and it's been legislated for. It really is an insolvency situation, so it's going to be of zero benefit to any ongoing concern, I'm afraid. Aline has asked, what is the effective date of the new law provisions in terms of existing employment contracts? The new law already applies to all employees. It's just that the contract, there's a grace period to change your contract, but the new law actually applies to all the existing employees and the new employees, everyone, as of the 2nd of February. It's just that the ministry have allowed us a year to issue new contracts for the existing staff. Sabrina, anything from your perspective there?
There was one that just popped in that I thought was quite interesting, actually. The calculation of end of service is still based on basic salary. Is there any clarification on the minimum percentage of basic salary out of the total package? No, there isn't. The law, the executive regulations do provide that where you calculate prorated annual leave for part-time employees, that is subject to a minimum entitlement of 5 working days, but there isn't a minimum entitlement under the law in respect of end of service gratuity. So that is just purely calculated based on the number of hours that part-time employee works.
Yeah. We're in our last 2 minutes, folks. I will just take maybe another one, and Sabrina take another one, and if there's, we'll try and pick up the others that we haven't got to and share the answers afterwards along with the slides. Manuel has asked, what if there is no auto renewal, the term expires and the employment relationship continues? In that case, it is a renewal, because the actions speak louder than words. The courts will consider, and the law has specifically said it, that in that scenario, it's a renewal without the necessary paperwork being in place, but the actions of the parties is suffice. Sabrina, do you want to take the last?
I think there's one on can employees take up freelance or part-time work in addition to full-time employment? I would say probably not, because the purpose of full-time employment is that you only work for one employer. Obviously, if your employer potentially agrees to you working for another employer or on a freelance or self-employment basis, then fine. But I agree, yes, where an individual works part-time or freelance, of course, they can take up various different positions at the same time, but where an individual works full-time, I imagine that wouldn't be applicable. They would only be able to work for their employer unless their employer specifically consents.
Thank you, Sabrina. Thank you, everyone. We're really grateful. We've had a lot of people on the webinar. It's a lot of familiar names. Great to virtually see you all, and we will come back to you with the PowerPoint, and also we will pick up some of those questions that we didn't reach and share the answers. So thank you so much for your time, and have a very good day.